Hey everybody, welcome to Lawyer Live with Matt the Lawyer. I am Matt Johnston, also known as Matt the Lawyer. Before we get started, I hope everybody will take the time to click the link that you see down there, or if you're not watching this on my blog, if you will go to mattthelawyer.com, very front homepage, you can click the link and buy my book, which talks about contracts and drafting contracts so that you, as the business owner, can develop your own contracts your way. Today I want to talk about a very particular kind of contract, one that I understand why businesses want them, but I also understand that most businesses are doing these things wrong, and that's the non-compete agreement. I had occasion to be reviewing a client's non-compete agreement, or more specifically, I was reviewing a non-compete agreement for an employee that they had just brought on. Now, this non-compete agreement was in a pretty common business area. Is one that we see all the time. It's pretty much insurance related, employee benefits related, these kinds of services. So this particular company had their employees sign a 3-year-long non-compete, which meant from the time they were hired until they were fired or terminated or quit or whatever, and then for another 3 years, this employee was not permitted to compete against the company in 5 states and the District of Columbia. Those states included Maryland, which is where we're located, the District of Columbia, Virginia, West Virginia, and Pennsylvania. Oh, I'm sorry, not West Virginia, Delaware and Pennsylvania. So it's a very, very broad geographic term and probably overbroad, probably not necessary. But what really got me interested about this particular non-compete was what was missing. See, a non-compete exists for the purpose of protecting a valuable business interest. Now, that interest could be anywhere from information related to processes, patentable material, any sort of trade secret. Those are business interests that are relatively necessary to protect. It may also be to protect a company's market position. For example, if they are a dominant player in the market, they may not want to have one of their employees leave and then trade in on the goodwill that they created while working for the company to create a competitor for the company. It's a little bit fuzzy. It's not the best business interest, but it is one that's in there. This particular contract that I was reviewing didn't have it. And moreover, the contract didn't even describe the business that the company was in. It was kind of vague, a little bit around the edges, talked a little bit about this, and then had this massively expansive, wide open definition of confidential information that couldn't be used, that couldn't be protected, or could be protected, but couldn't be used by an employee who left. It was probably an unenforceable contract because or at least as it was written, it was unenforceable because it's so overly broad and so not tailored to protecting a business interest. So if you're going to be looking at a non-compete, this is the things that I talk to clients about. You need to make sure that you address 3 things. First, you need to be sure what business interest that you are protecting. Simply protecting your market position may not be enough, probably isn't enough. Simply protecting against some employee leaving and starting a competing business, probably not enough. Now, what you can do with a non-compete is you can limit things. You can say, we have a business interest in our clients and our customers, so you can't solicit those. A non-solicitation agreement is a kind of non-compete, and it's a little bit easier to enforce. Actually, I take that back. It's a little bit more difficult to enforce, but it's a little bit easier to get past court scrutiny if you're ever in that situation. Because you're saying to this employee, you can go ahead and compete with us in this industry, but you can't talk about you can't talk to these people, these clients, because they're our clients. And you used your connection with this company to develop that relationship with us. So what is the business interest that the company is trying to protect? Number 2, what access or what creative enterprise that this employee did went into creating that business interest? So one of the things that a non-compete is designed to do is to protect a company against the goodwill that was created by an employee while working for that company. So employees that have a close working relationship with customers, with clients, or have an intimate knowledge of a particular trade secret or a process, having that protected because the employee contributed to that, that is a business interest that can be protected, and it addresses how this employee was working with it. So one of my other clients has a very important project manager. This project manager is the primary project manager on almost everything this company does. If she's not the direct project manager, she's supervising other project managers. She has a lot of face-to-face, very long-term interaction with clients. Having her leave that company and go and set up a competing company in the area could have a very devastating effect. Fortunately, my client has also recognized that and well compensates their very senior project manager. Now, the third question is one that always comes up. What is a realistic geography and time for the non-compete? Now, geography is a little bit difficult because the larger or the more niche the company sits, if they sit in a niche market or if they're one of the dominant players in the niche market in a geographic area, you kind of want to be able to restrict that. And I get that, I understand that. But you have to sort of be realistic. In the one that I'm reviewing, really, employee benefits insurance in a 5-state region, that's a little obscene. The company was based just outside of Baltimore. Are they really competing with a company that's based in Blacksburg, Virginia? Probably not. It'd be a hard stretch to say they're competing with somebody in Alexandria, Virginia, which is just across the river. So it's a little difficult to make the case that this big 5-state region is what should be applied. Similarly, are they competing with somebody in Hagerstown? Maybe. Cumberland, Maryland? Probably not. Pittsburgh? Almost certainly not. And yet, when you say the entire state of Pennsylvania, Pittsburgh and Erie, Pennsylvania are a long way from Baltimore. And it's highly unlikely that they're competing in those markets. So think about what is a reasonable geography, what is a reasonable time frame. Because when you create a non-compete, you are telling somebody you cannot pursue your chosen profession in this area for this amount of time. So you have to be very careful about that because the courts don't like that. But I also had occasion this week to deal with a very interesting sort of twist on the non-compete, and I call this the training cost clawback. Now, training cost clawback is there's some period of time after the employee is hired that if they leave, they have to pay back the company for some of the training costs. And this particular one had a very steep training cost, and which was probably necessary. I'll be honest, it's probably a necessary training cost. And then a 3-year period in which that if the employee left any time within that 3-year period, they had to pay back a portion of those training costs. Now, in a way, this is a bit of a non-compete. They're saying to the employee, if you leave us, after we have paid all of this money to train you and how we do things to help you get your special certifications and licenses that are necessary to do this business, if you leave within that time and you do competing work for another firm or an entity or even yourself, then you've got to pay us back some of that time. So it's not a retroactive or even a prospective non-compete. It's just that within that period of time, we're not going to say you have to stay here, but you're not going to be able to take our training and go set up your own business. Now, in a certain way, I kind of like this particular clause. It's a bit more honest. It says right up front, we're spending X number of dollars to train you to service our clients, our company, our brand. And if you take that knowledge that you gain from that and you go somewhere else, fine, good luck, but we want some of our money back. And I think that's a fair and reasonable estimation. It still gives the employee the ability to choose and follow their profession, but it says that you're going to pay us for acquiring the knowledge that you acquired through us. So think long and hard about non-competes. I understand why they're necessary, but This isn't something that you just want to pull down from the internet and not think about. It really does require some significant cost-benefit analysis and some significant understanding of what the risks are, as well as what the law is. It is kind of this evolving area of the law. I hope if you're having any trouble with non-compete agreements, you'll give me a buzz. You can give me a phone call or send an email or use that little contact information thing on my website. Again, my website is www.mattthelawyer.com. And in the meantime, go out and watch some live soccer. I'll talk to y'all later. Bye-bye.